and get started. And we have a great presenter co-host with us tonight, Josh Borger with Berliner Cohen. And he is going to talk about a lot of different legal things that we need to be aware of with COVID and what it presents. And this guy, I'm telling you, like, he is the attorney's attorney. So you're in for a real treat. We're going to go ahead and get started with some of our disclaimers that we always start with. So the first one is everything that we share with you is simply education, and we don't endorse, warrant to do your own due diligence in regards to legal and tax. And if you make an investment, we say this all the time, if you make an investment and you make a profit, I'll let you keep it. And if you make an investment and you lose money, I'll let you keep that too. So it's all is to provide education, networking, and inspiration so that we can enable you to make wise and profitable investments. When we polled our audience, we found that over 78% of our regular attendees have done business together. So this is the place where deals happen. I just want to let you know that coming out here in August is going to be a book that I've written. Randy Farias and I have put together the Influencer's Impact. So be watching your emails and you'll learn about how you can use influence to impact lives or income. If you know about a deal or you have a deal that you're looking to participate in, feel free to give us a call. We'll do a quick deal review and see if there's something that we can do to help you. So I'm going to turn this over to Liz. You have your PowerPoints up?
So yeah, basically like the last, during the last recession, or 2008, unemployment rate was 8%, and now it's 14.7. So it's going to have a huge factor on the housing market. And so unemployment rose higher in 3 months of COVID than it did in the last 2 years of the Great Recession. And then the feds expect unemployment rate to stay high. And now we have the second wave, which is upon us due to the second peak of COVID. And so basically the coronavirus mortgage delinquency rate could surpass the Great Recession. This is due to the statistics that are coming out now. So the foreclosures back in 2008 were about 616,000, and now we're looking at close to 15 million. So that's a huge increase, and it's going to have a huge impact on the market. Okay. Let's see. So yeah, homeowners stopped paying mortgages in record numbers in April, and the serious mortgage defaults will increase fourfold by mid-2021. And these are based on statistics from CoreLogic. So basically, the good thing is the mortgage rates are at an all-time low. The historic low is what, 3.3 for about 4 weeks straight in a row, which is pretty incredible. Okay, so in a normal market, we have about 5% distressed properties, and with the shift in the market going on now, we're going to have about 30% of distressed properties in the market, and that's coming soon. So today the MLS put out some statistics. Let me see if I can increase this. So the statistics that they put out today were showing that there's basically 30% decrease in inventory from last year. So, and basically what they're saying is that's due to people being scared of COVID. They don't want people coming through their properties. They're not sure what to do during this time. So there's a lot of confusion in the market. Although because there's not as many listings on the market, the prices have remained pretty stable. So that's, at least they haven't decreased yet. So yeah, that's about it, basically in a nutshell for the just the important factors that came out today in the market. That's Santa Clara County. But you know, with all the doom and gloom going on, the historical data does show that the market will boom after 2020. So you know, we're just going to have to go through that. There's a lot of factors in the commercial market also. The retail market wasn't doing well even before COVID, but now that COVID's hit, it's even doing worse. So there's going to be a lot of transition. For instance, in the shopping malls, there were statistics that show that about 300 indoor shopping malls are scheduled, you know, likely to be closing within the year in the United States. But because of, you know, the change in the demographics and things going on in the market, those properties will be converted, and the developers will be looking at those to convert to meet like the increased statistics in the seniors. There's like, what, 10,000 people every day turning 65 in the United States. So assisted living situations are going to be in high demand. So they may consider turning some of that into assisted living, and also changing it from retail to mixed commercial use. So just a lot of change in the market. Timing, you know, COVID has a big factor on that. It's kind of, you know, increased our time frames as far as, you know, you see in the news every day, things are closing, things are opening. It's kind of all based on, you know, what's going on with COVID. And then of course, in the housing market here in the Bay Area, you know, in the state of California, actually, we have the foreclosure moratorium. So that's also increased as long as, I think it was extended out to September. So yeah, there's a lot going on. But so in a nutshell, that's what's going on. Sorry about
Okay. Well, listen, everybody, you know, we're gonna push through. We're gonna push through with this, all right? So we have Josh Borger. Everybody knows Josh. Josh is a partner at Berliner Cohen, and we'd like to welcome Joshua. Josh has sent me some questions earlier today, and I put those on this slide here. Joshua, can you see the questions?
I can't, but that's okay because the judge asked me questions and I don't see those ahead of time either.
That's funny.
Okay, so you cannot? Okay, hold on. Let me
I don't need to. You know, when I used to interview lawyers, I used to ask them Stones or Beatles, and they always looked at me like I was crazy. And you know why I asked them Stones or Beatles? Because you're going to go into court, I tell them, and you're going to think you're going to be talking about A, and the judge is going to ask you about Z, and you're going to think it's like Stones or Beatles. So ask away.
Okay, I'm gonna ring the bell and a restart. Okay, can everybody hear me? All right. So you know, Josh does business litigation law, and he's got a lot of experience, and he's right there in San Jose, California. So he's a good person to know. And so, Josh, I've got your insurance questions here, right? And I'll just read these out. Probably the biggest insurance issue now is that businesses are shut down and they want insurance to pay for lost in business income. Is that possible?
It's possible, and the thing is, right now, insurance companies are getting hit left and right with claims for business interruption coverage, is what it's called. And this is throughout the country. You probably heard in California, Thomas Keller of the French Laundry filed a lawsuit against his carrier for business losses due to Bouchon and the French Laundry. Alice Waters, I believe, filed more recently. Can you get it? It's going to depend on so many factors. Thomas Keller said that he's filing because he has probably close to $100 million and he can afford to do it for everyone. The problem I have with that statement is Thomas Keller has a certain type of policy, and the odds are the rest of us have something else. And I think the court may draw that dividing line of Thomas Keller on one side, the rest of us on the other. I'm going to get into the depths of it, but the real answer to that question is, it is possible. It's probably more likely in other states, in my opinion, than California for reasons we'll get into. But that is because of some old case law interpreting old contracts, which were dealing with situations that are long before even the last 30 years where everything is done on computers. They were dealing when everything was tangible and the only thing you were dealing with was a physical building. But we'll get into that.
I get it. So first party policies cover property damage, right? Is this the shutdown of a business property damage?
Well, that's where the rub's going to be. And a lot of people are saying no. And the answer is, you've got some good arguments that the answer should be yes. So let me give you first, what is first party versus third party coverage? First party means you're seeking under your property policy, which all of these are property policies. Business interruption coverage is a property policy. You're seeking coverage for losses that you sustain. Third party means someone is suing you and you want your insurance company to pick up the lawyer and to pay to either settle the case or try the case and pay for whatever judgment is, hopefully not, but if it is, that it's against you. So the first question is, if your business is shut down due to the coronavirus, you can't operate, is that a property loss? And that's where I think you may have a better chance in some other states. There's a case in Colorado, for example, where a church was filled with methane. Physically, the church was fine, but you couldn't go in because it was filled with methane. So the Colorado court said that's a property loss because you couldn't use the property. It physically looked the same, but you couldn't use it. There were other cases, a West Virginia case where property was undercut. So if you went in, you'd fall to your death. Hadn't fallen yet. And they said that's a property loss because nobody in their right mind is going to go in. But the property looked the same. California has some cases in different contexts, though, stating where if you don't see a physical difference, it's not a property loss. There was a case dealing with, it was an MRI machine, and the machine broke. And the court said that wasn't a property loss because the machine was physically fine. It didn't drop, it just wasn't working. So to the unaided eye, the machine was fine. There was another case dealing with drives, computer disks, and the data was lost. And the company sued saying it's property damage. And the court said, no, the disk drive is fine. The data is a bunch of X's and O's. Now, I have a problem with that because that opinion eviscerates the entirety of intellectual property. If you were to ask that person whether they thought they were paying whatever every month in premiums and so forth to cover a $2 disk, I think they'd say no. And I think the court erred in that. But those are the opinions we'll have to wrestle with. There is a case, however, dealing with a house that was undercut. And the issue was whether it collapsed. It hadn't collapsed yet. But the court said no reasonable person would go inside, so that's a collapse. Now, if you were to ask anyone, they'd say it's on the verge, but it hasn't. So you could make the same analogy and say that it's a property loss because no reasonable person's going to go into my business, just as the house hadn't collapsed, but no reasonable person's going to go in. We'll have to wait and see what the court does there.
Does it matter that the governor is the one that shut down the businesses?
It may. There are some cases dealing with the government and if they shut you down. And there's some policies that deal with that. The policies that have that, if the government shuts you down, the benefit is that that usually doesn't require a property loss. So look at your policy because you may be able to get around that conundrum we were just talking about if the government is the one who said you can't operate right now.
And how much is covered?
That is going to depend. Under some policies, it's going to be a set amount, $1,000 per day. It's going to be for a certain period of time. There may be a minimum, but not a maximum. There may be a maximum, but not a minimum. It should be in your policy and state how much, but it's all going to be very different.
I get it. And how long is the lost income covered for? I think there's going to be losses for a long time, right?
Right. Well, that's the thing. This is business interruption. It's not meant to be a lifeline forever. So your policy will likely say, most are 12 months, but it's likely going to say how long. Because again, it's a business interruption. And how long that interruption is going to be. If you are going out of business and you are forever out of business, this is not what you fall under. Unfortunately, you fall under the bankruptcy code.
Does it have to be a complete shutdown, or can it be a slow down in business?
And I like the way you said slow as you went on. I haven't had anyone ask me that.
Can it be slow or slower?
Right. It's a suspension of operations. And funny enough, different policies define that different ways. Some say it has to be a complete cessation, all stoppage. Some say define that as limiting what you did as well as completely stopping. So you have to look, your policy could go one of two ways on that one.
So I got the next page here. What if the business never recovers, it goes under and doesn't reopen?
Well, that's not going to be business interruption because it won't have been interrupted. If it doesn't recover, then it's going to go into dissolution, or it may just go into bankruptcy. Not everything that dissolves has to go into bankruptcy. If it simply never recovers, the odds are it's not going to get insurance because it won't be a temporary cessation. It'll just be out of business.
I get it. Okay, I just let Shankar in there. Okay. Can you still get coverage? How do you prove lost profits?
Right. In order to prove lost profits, you can't just make a claim and say, I would have made a fortune. I haven't actually started yet, but I couldn't start due to the coronavirus, because you had to prove that you made profits. In any litigation, in order to claim lost profits, you have to show a history of profits. And that would only make sense, because everyone otherwise is going to say, I would have made a fortune if you just let me. And there's no way to base it. So you'll want profit and loss statements from prior years. Taxes are privileged, but you can give your insurance company taxes. You'll want to give them proof that you have made profits in the past in order for them to be able to calculate what profits you would have lost during that period. And you'll probably only want to go back about 5 years, but that is standard to be for good measure.
Josh, are there typical policy exclusions to look out for?
There are pandemic and pollution exclusions. Those exclusions, and I'm not saying they're all going to work, you have the burden of proving you fall within the policy. The insurance company has the burden of saying you fall within an exclusion to the policy. So after SARS epidemic, the insurance companies started adding exclusions for pandemics because they realized they were on the hook. And so you have to look and see, do you have a pandemic exclusion? Now, I expect a lot of them to try. They're going to throw everything out there to try to deny coverage. They'll probably rely on a pollution exclusion. I don't think the pollution will work because that is a standard pollutant, and it would be very hard to argue that what's happening now is a standard anything. Those were meant for environmental pollutants. They're not meant for what's happening now. But they'll try.
I get it. What if I told my insurance broker that I needed coverage for this type of event, but I didn't get it?
If you told, and this is why everything has to be in writing. Memories are convenient, and frankly, in my business, people lie. So when you are telling your insurance broker what you want, be very clear and put it in writing. Because if they do not get you what you need, and you thought that you had gotten X and they got you Y, your insurance company will turn down the claim. And they will be right if it doesn't fall within. But then you're going to sue your insurance broker because they got you the wrong policy. And so you are going to want everything that the insurance company would have given you from your broker. And your broker should have insurance for that.
Get it.
That's professional.
So people are going to get sued out of this. Our commercial general liability policy is going to come into play. And what other policies should people seek coverage under if they get sued?
Right. Commercial general liability policy is what's known as a CGL. You've probably heard that. it's going to pay for property damage. It's going to pay for bodily injury. These are policies that are the third party. When somebody sues you, there's any number of different policies when somebody sues you. The people who are on the cruise ship, they're going to sue the cruise ship. They're going to claim that they were injured, they got this disease due to what was happening on the cruise ship. They're going to run into the same problem as property damage as before, but they're really going to claim bodily injury. I expect the plaintiff lawyers, when the courts really open up, to start filing lawsuits left and right against people. If you're a professional, if you're a doctor, for example, on the boat who gets sued, you're going to have an errors and omissions policy. Those are professionals. Directors and officers policies, they cover board members, directors of companies. They are also going to get sued. I'm just reading the tea leaves. It's going to happen. When the courts open, people who have this, who were trapped on the boat, are, for example, going to claim this is their injury and they will sue.
If my insurance company denies coverage, is that bad faith? And what is bad faith, Joshua?
Sure. Bad faith means if the insurance company denies coverage, if they just deny it and they're wrong, that's a breach of contract, your insurance contract. But if they deny it and they had no reasonable basis to deny it, then that is what is known as bad faith. And the reason you want to sue them for bad faith, if you can prove it, is then you get to recover your attorney's fees from the insurance company. So if you hire me, for example, and you prove bad faith, the insurance company is going to have to pay you damages as well as my bill.
Okay. Are there any parts about insurance coverage that you'd like to address before we move on to commercial leases?
Some people asked the last time, I believe, about lost rents and whether they would be covered, about vandalism, whether that would be covered. So let me talk about those two things. Let's start with vandalism. Well, due to this, and I'm sorry, vandalism wouldn't be due to COVID-19, but due to other things that we're seeing right now, if people are seeing vandalism, people were asking, is that going to be covered? That should be covered because that would be a physical damage to your property. If people are breaking windows, if people are stealing from you, those should be covered. Again, should be because you have to look at the policy. But those, more often than not, will be covered. That's a typical property loss. Lost rents, again, if it's due to COVID-19, then you're going to run into the same problem as whether it's a property loss. If the real trigger was the COVID, if it's due to something else, due to vandalism, then you may have a better chance at that one.
Okay. So I've got some commercial leases questions here, okay? So when retail establishments open, there's going to be a dispute between commercial tenants who cannot pay rent and their landlords. Go, right. Before I get to that, though, I want to give a precursor for why you really need to pay attention to this section. There was a bill in the state legislature that was meant to deal with everything we're going to be talking about right now. Was meant to be the Band-Aid. It was the temporary. And they were debating a legislative fix-all to deal with all this because no one was sure what the courts were going to do. That legislative fix-all has failed. Recently, it has failed. And if you heard that it got voted down, that's not what happened. It got stuck in a committee technically, and it did not get voted out of committee to go to the floor to get voted upon. So what that means is it's going to get stuck in the committee, and if it doesn't get out by the end of August, which it will not, then it is going to die on the vine. So that bill that everyone was looking to, that the landowners, the landlords hated, is going to die. As a result, there is nothing that I'm aware of that's being thrown around in the legislature right now as a potential alternative. It is now going to be up to the courts. So what I'm talking about now is very important because as of today,
This is going to be where we're at. The courts have issued an emergency order that currently stays evictions. The legislative fix was supposed to be what happens after that. But what's happening, what I'm going to talk about now, is going to be reading the tea leaves, because lawyers look at past situations, and I have gone back over historically past analogous situations to show you where, in my opinion, we are going to end up because we do not have a legislative fix. So yes, there is going to be a dispute between the tenants who are then told, go back and operate, and they've been out too long. Some of them will never recover. You cannot say, just go back and operate your business. They're done. And the landlords who still have to pay their mortgages. My advice is always come to a reasonable solution, all of you, landlords and tenants. But if you want to sue, I've read the tea leaves to tell you how I think it's going to turn out.
Yeah. One of the big issues is whether the lease was terminated because the business couldn't operate. For example, if the lease states that the purpose of renting the space is to open a restaurant and the tenant couldn't due to stay-at-home order, is the lease terminated?
Right. And it would be very easy to say yes. The problem is the simple answer is never the legal answer. The legal answer is always it depends. Your lease will say in there that it's a purpose of the lease. Leases typically say the purpose. But just because it says the purpose doesn't mean that you have to do that. If you have a purpose in the lease and you're not allowed to do that purpose, if it just says a purpose, then you can do a reasonable alternative. You have to be allowed a reasonable alternative. And we'll get into debates as to what that reasonable alternative. If you had a restaurant, your landowner may say, we'll open up a dry cleaning business. And we would say, well, that's not reasonable. It's not analogous. That makes no sense. But you can have that argument. If your lease, however, says that you had to operate a restaurant, for example, and you didn't have a choice, that's beyond a purpose. That's a requirement. And as a result, you would have an issue. I'll give you an example. And I'm going to go through and tell you these examples. We live by examples as lawyers, and it helps you to frame how I came up with this. A lot of these cases come down from World War I and World War II. What we're going through now is the equivalent of a wartime scenario. There was someone who purchased a hotel in an area that was known as Little Tokyo during World War II around Los Angeles. And they said their intention was to open up a hotel that catered to Japanese. But after the evacuation of the Japanese in World War II, they couldn't operate their hotel. They had no people. And the court said that did not get you out of the lease. That may have been your intention, but that was not agreed upon intention between the person who sold it and the person, or the person who was leasing it and the person who was, leasing it to them. That was not agreed upon. That was your subjective intent, which is not enough. If everyone had agreed upon it and you couldn't do it, that would bring you into line of what's called commercial frustration. And that's what we're talking about. Commercial frustration is what we're all going to deal with here. You were going to do something, the other side wanted to let you do something, but due to some frustrating event that was beyond anyone's expectations, there's nothing they could do about it. This contract has been frustrated. And the court said here, no, it was just one side who got frustrated.
I think one of the examples that you used last time when we spoke was that if a company had carry out or delivery, right, and then was shut down, then if they could have carry out or delivery afterwards, right, then what was the effect of that? Maybe you can describe that example better.
Sure, and that comes down to governmental restrictions, and historically, do you get out if it makes your lease less profitable or completely unprofitable? And follow me here, because in a certain way, it makes no sense what I'm about to say. But it is what the law is coming to. Sometimes we don't make a lot of sense. There was a case in World War II again, around that time, 1944, where someone leased a neon sign. And then the government said, you can't have lights on at night because you're telling the enemy where the land is. And so they got out of that lease. because you can't do anything with a neon sign. The other side said, put it on during the day. And they said, no, the whole point of neon was night and they can't use it. You all knew that, so you're out. Okay, it had no value. It was a neon sign to be put on at night. It had no value. So the government said, you're out of the lease. Now, someone else was operating a car dealership. And due to the war effort, they were not able to operate at full capacity. So they tried to get out. And the court said no. That was the California Supreme Court. They said, you have not lost all value. You are just not operating at full capacity. You're still making money. You were just hoping you'd make more money, and we never said you'd make all the money in the world. So if you were making no money, you got out of it. If you were making less than you had hoped, you didn't get out of it. Now, fast forward. Some restaurants were only dine in, and the dine in were not operational. So under that analogy, they could terminate. Subject to everything else I'm saying, if it's just this, they had a business that if the lease said you had to operate the restaurant inside, and they couldn't do it, and there was nowhere outside, they could get out. But if they had takeout, they were, even though they weren't making very much, the argument here would be that you were still operating, you just weren't operating at full capacity. And here's why that in some situations will make no sense. You may have been losing money doing takeout. At the same time, you had to keep doing takeout because you had takeout. You would have been better off, some businesses, not having takeout than having takeout. That's it. You would have been better off for some people shutting your doors, going bankrupt, than actually doing takeout and continuing to lose money. Now, if someone had takeout, let's go a step further. I'm going to beat you to the punch with that question.
There you go.
You're going to ask me, well, if they had takeout, can they just stop takeout, right? Okay. I don't know, but I'm guessing no. If you had takeout and you realize this halfway through, I'm losing money doing takeout, I'm just going to get out of this lease and shut and say all I could do was inside. I don't know what the court's going to do there. I tend to think the court's going to say no. You can't do that. You can't go backwards. But we're going to see. Someone's going to test that, and we're going to see.
So, you know, everyone's entrepreneurs, everyone's got the business, and they want to make some money, right? So maybe the advice I'm hearing, right, is that if you're struggling, right, your business is closed for something, and you might think of some other reason, some other way to make money, perhaps the best advice is to talk to you first, right, to see if that's not going to put you in some sort of a position where you have to remain open but at a loss. Is that what I'm hearing?
There's so many factors that I'm going through now that I can't say one size fits all. No one can in the law. It's not that I'm trying to stay employed. It's not possible. There's so many situations, and I've seen so many different contracts where I read something, scratch my head, and think, who on earth thought it was a good idea to put that provision in there? But that may be the very thing that you end up litigating that could help you or kill the case. And so read it. That is especially true for insurance. I always referred to insurance as contracts on steroids, because every word likely has a history of case law interpreting that word.
Okay. Well, I think that leads a little bit to the next question. What if the government's restrictions make the lease less profitable, but not entirely unprofitable, such as a restaurant that can't seat guests but can still provide takeout, etc.? And we addressed that just then, right?
Right, that's what we were talking about.
Okay. Is the lease terminated automatically or just stayed due to stay-home order? And I think that was something we just addressed, right?
Well, not exactly. Here's the thing. Let's go into that a little bit, because that's also a very interesting wartime situation that we're going to have to wrestle with. We don't know when this is going to end, and it appears that now it might be getting a little worse, and we might be going a little backwards. For the lease to be stayed, if you could argue that right now it should be stayed, but whether the stay at some point becomes permanent, even though we know this is not a permanent situation. At some point in the law, the temporary becomes permanent, even though we know it's not. I'll give you another example for what I mean by that. There was a case dealing with shipping containers and ships that were going out from San Francisco Harbor. And they said you can't during World War II because there's submarines out there that are going to blow up the ships. And the ship said, well, then we're going to breach contracts. And the court said, no, this is deemed permanent at this point, so you're going to get out of it because we don't know when the war is going to end. We don't know when this is going to end. So at some vague point that nobody knows, some court is going to say, the temporary has become permanent, even though we know we're going to get out of it, just as we know World War II would end at some point. But at some point, the temporary, the court said, became permanent, and people were allowed out of contracts.
I get it. Well, listen, I've put out in the chat that if anyone has a question that they would like Joshua to address, and address within, you know, the ballpark of, like, we don't know the details and everything's in the details, right? So if anyone has questions, you can submit those into the chat window now, and we'll address those. Have you had an increase in a lot of these types of issues and cases lately? I'm sure you have, right?
Well, I can tell you right now, we're not sure what's going to happen. I was scheduled to be in trial a week after COVID hit and the shutdown. And I will find out in August when my new trial date is. And the judge said, very frankly, he doesn't know how this is going to work. None of us know how this is going to work. Everything is happening new. The judges don't know. We're doing depositions right now in hearings via Zoom. We're all learning in every profession how everything is going to work out.
It's the same here. Everything's shut down. All the courts are shut down. You're in Santa Clara County, right?
I'm in Santa Clara. It's not shut down.
Oh.
Certain things are open, and certain things have gone back to being open. You can get a hearing. They're just doing it differently, and it may be out a little farther than you had hoped. Things are working differently. We've accepted that you cannot shut down the courts forever. People need access to courts. We just need to figure out how we're going to do it. And we're figuring it out as we go.
Yeah. Well, I don't, Joshua, you know, I want to thank you for your time and your patience through the, you know, the interruptions of the internet. And, you know, if anyone would like to contact Joshua, I have your contact information on the screen now. I think everyone can see it, right? And you're on Almaden Boulevard, 11th floor, right?
Almaden Boulevard, the 11th floor. Our office, like a lot of offices, is shut down right now. So like a lot of people, I'm working from home, but you can email me. You can call me with any questions. I'm happy to help you at any time. I'm a general business litigator, so my litigation and real property litigator, it runs the gamut. I'm happy to help you with these or any other issues that may arise.
I have a question here. Josh, what do you read in the tea leaves in regard to mortgage companies foreclosing on commercial leases because of non-paying tenants? I guess that's a big question.
No, that's a fair question. I should probably also break the news I'm a coffee drinker, but that's okay. So right now, I believe I mentioned last time, right now under the Judiciary Committee has changed the rules. We have emergency rules, and there are no foreclosures right now. At some point, I'm sure that emergency rule will change. I believe it right now says that it's 90 days until after the governor lifts the emergency. And that's why they were hoping that the legislative fix would start when that would end. I have a case right now, I think I mentioned last time, where somebody filed in federal court to try to get around the California stay because their theory was the stay didn't apply in federal court, it applied to state court. That's clever. I would expect some other people to try that. I don't think that's correct. In certain instances, state remedies apply in federal court, and I believe this is one of them. But that may be what people do, either because they think they'll be successful or they think they'll scare people to the table and coming up with a settlement. Keep in mind that is only judicial foreclosures. Most foreclosures are non-judicial foreclosures. So if you can do a non-judicial foreclosure, then I would think most people are going to try to do non-judicial foreclosures. The problem there is obviously going to be anti-deficiency, that when you foreclose, that's all you're getting.
Get it. So is there any other area about commercial leases or any topic that's current that you'd like to address before we end? I think we're going to end here, right?
I'm happy to answer any questions, but if nobody has questions.
I don't have questions that are relevant. I have a question. I have a question about this. You know, the thing I sent you, right? So here, I have one from Nazir here. Do you think we'll have another 2008, which is, kind of like a financial question? So
well, I'm not
go with that one.
right? I don't know. You should ask Greenspan. I'm not exactly sure. I shouldn't be the one to answer that. I hope not, but
Yeah, let's hope not.
I think we all hope not. Right now, I can say that bankruptcy courts are not filled right now. Mortgage people holding the mortgages and so on and so forth, they're still trying to figure out what they're doing. A lot of people thought bankruptcy courts would be flooded right now, and from my friends in bankruptcy, I'm told they're not, and not very much is happening in those bankruptcy courts right now.
How can you speculate? How long do you think that we'll be in this state, the state of nothing happening?
The state of nothing happening is going to be until,
sort of
I mean,
like,
my case where it was a federal court is an anomaly. You have to jump through certain loopholes to get to federal court. And for the situations like real property, it's rare. I have a rare case that ended up there. So for most of them, they're going to be stuck with state court knowing they can't foreclose in court. And the court is not going to change that and allow foreclosures under these circumstances. So we're all just waiting to see what the governor does. If it gets worse, the governor isn't going to lift it, I hope. And then it's 3 months till he decides otherwise. This could go on for quite some time, that we have no foreclosures.
Would you say that lawsuits are going to increase if there's no legislation?
Oh, well, I was talking just about the foreclosures. So the impact on lawsuits, you can file right now lawsuits. And so I would expect right now the plaintiff's bar is gearing up, getting clients, and is going to file personal injury claims, damages. Now they're going to have a heck of a tough time proving causation that somebody got COVID because of X, Y, and Z. Maybe if you were on a cruise ship, it's easier. But other than that, it's going to be very difficult. But I would expect we're going to see a lot of COVID-related claims. Beyond that, I think as far as the insurance, people are, and I don't think it's a good thing, waiting around for the insurance because they're being told, wait to see what happens with Keller's suit. But let me tell you a little bit more why I said it's not important to wait for Keller's suit. Thomas Keller has what's called an all-purpose policy. All-purpose policy means everything is covered unless it's specifically excluded. And exclusions are read very narrowly by the courts because it's the insurance company trying to get out of something. Most of us do not have an all-purpose because if you have a policy that reads that way, it's going to cost you a lot more. Most of us have a policy that covers bodily injury and property under these, or just property if it's first party, and then you have exclusions. So that's why I think the court is not going to want to say everyone wins, including Thomas Keller. And the reason they're not going to is because if insurance companies go bankrupt, you know what happens in California? Somebody raise your hand. You know what happens? The state has to pick up the tab. Can you imagine that? Insurance companies in California go belly up because of the number of claims. If you can prove you actually had coverage, the state picks up the tab. Wow. No judge, I don't care how much you say they don't succumb to political pressure, is going to be the one to say the state should pick up the tab for every insurance policy.
Yeah, that is crazy. How about, it wasn't in the bullets, but how about personal injury? Like say, for example, if you're hurt or, if you're involved with something that can be proven that you're responsible or someone else is responsible, liable. How is that? in relationship to the riots and COVID-19? How about that? Or even illness, COVID-19 illness. How about that? What's the relationship there?
Are you, help me to understand. You're sick, or somebody is sick with COVID-19,
Right.
and who is it they want to sue and why?
Well, I'm just saying that if say, for example, if you were involved, if a person was involved with protests and they were injured, if they were, say, for example, if they were at their business or workplace and they got sick, right? Would the employer be responsible? Do you know what I mean? I'm looking for.
Oh, so yeah, I think right now people are discussing whether this would be covered by workers' comp if you're injured at work due to COVID-19. You're gonna have a causation issue there. It's gonna be very tough for people to prove where they got sick from COVID-19. If you got it from someone because you were protesting and you got COVID-19, again, you're gonna have a tough time proving it. They're not gonna have any insurance that's gonna cover it. You'd never be able to prove who did it or how you got it. That'd be virtually impossible. Proving how you got it, causation is what it's gonna come down to. I don't know how people are gonna be able to prove that.
I get it. Well, listen, everyone, I'm asking for questions, and maybe Joshua, you've just covered everything so well, right? So we're gonna have last call for questions here, and put those in the chat, please.
And if you want to ask me something off the wall, I'll give it my best.
Okay, you asked for this, okay? So
I did ask.
what is this? The non-discrimination. Okay, so there's going to be a vote in the next election. I'm not in California, okay, but California is voting to eliminate the non-discrimination of people. What is it? Do you remember what that was?
The non-discrimination of people.
Maybe I'll just leave it there and send it to you privately so I can.
I'm not exactly sure. Let me tell you why California ballot initiatives.
My desktop is at such a fragile state right now. I don't want to close and change any windows.
California makes law tough. Let me tell you why. Ballot initiatives. You have different kinds of laws. You have case law, you have statutes in every other state. California has a hybrid of ballot initiatives. So we end up in a legal muck of constantly trying to figure out which one wins when you have conflicts between the legislature, the case law, the ballot initiative. And every time we pass more ballots, we end up in this incredibly difficult situation of figuring out which one contradicted which one and which one now wins.
Okay, so well, listen, Joshua, thank you, and thank you for your your patience when we. Oh, I have one here from Paul. Okay, so Joshua, you practice in California, and you practice homeowners HOA law, and if so, what are generally the rules around CC&Rs? So I don't know what that acronym is. I probably should know.
The CC&Rs are the rules governing the homeowners association. I'm not sure exactly what you're asking. You have the CC, specifically special assessments.
Right.
Okay. So you have special assessments are when you have, for example, you may have an assessment because everybody needs a new roof. And so you're going to have votes and you're going to have special assessments that should be addressed both in your CC&Rs, and it's also addressed in the Davis-Sterling Act. If you want to Google that and look that up, the Davis-Sterling Act is the act that governs homeowners associations and CC&Rs in California. Your CC&Rs for your home will probably be some variation of that. So your CC&R should specifically say how you have to allow for the special assessment, and then you'll want to look up the Davis-Sterling Act because that'll tell you exactly the rules that the association had to create, that they were using to create. The Davis-Sterling Act is essentially the constitution for your individual HOAs. So those are where the rules are going to be found. I can't tell you off the top of my head the ins and outs of all of it. Davis-Sterling Act is very procedural. It would be impossible to memorize. I did have a case dealing with that last year because a couple of years ago they pulled a section out of it because they were trying to apply it to commercial associations, and it didn't work. And it was only a few years ago when they finally accepted it didn't work. So they created two acts. You have the Davis-Sterling Act, and you have this Commercial and Industrial Act that deals with everything else. But pre a certain year, both of them were still under the Davis-Sterling, even though Davis-Sterling didn't work at all for commercial.
I've got a question here. In a real estate showing, right? You know, when someone goes and looks at a property, if either the tenant, I guess it's the tenant, right? If the tenant gets a virus, can the broker be sued? This sounds like a familiar question from before.
Right. Is this purchasing property? So someone is looking to purchase property, goes in, there is a broker there who's the broker for the seller, and the person who's purchasing contacts the virus, and they're going to somehow claim that the broker or the property gave them the virus. Look, people are trying these waivers. You can certainly try a waiver for someone to go in. A lot of these waivers in California, some of them hold up. California is pretty good about wanting to hold up waivers. A lot of places aren't. And then that came up a lot with sports. And virtually every time the California Supreme Court said, no one is forcing you to do these things. So you're waiving any injuries, and that's fine. And the last one that came out was rafting. So my first bit would be, if you're the broker, ask for people to sign a waiver. And if they don't want to come in, that's fine. Can they sue? Anyone can sue anyone for anything. They may have no basis. They may get sued for malicious prosecution later, but nobody can stop you. The issue then is going to be, what are they suing you for? If they come in, they're not going to sue you for, I would highly doubt, intentionally doing it. They could sue you for negligence if they can prove that somehow your negligence caused it. But that's going to be really tough.
I get it. Well, listen, Joshua, thank you again. And, you know, okay. So I've got one last question here. Okay. If you apply the EDL loan with applying time period, and the government runs out of money, is government will have pay when we, so I guess is the government responsible for running out of money? Gosh, I'm not sure.
For running out of money? That's not
I'm not sure.
Really a legal question.
I'm not sure about that question, but what I have is I'm going to put your information in the chat, and everyone with your specific questions, you can contact Joshua, and that's okay, right?
Of course,
I'm volunteering you.
Of course
and,
it is.
You know, you've just really been a gentleman through all this, and thank you. It's been a little rocky because of the lack of internet.
That's okay. This is real life, everyone. Everyone stay safe. Thank you very much for your attention.
There you go. Be patient. So thank you again, and I'm sure we'll talk again. Okay.
That sounds great. Take care, everyone.
Thank you so much.
It's relevant. It's right now.